Greetings to you all and welcome to Grade 8 Tutor. My name is Afari Ernest and I'm going to take you through Business Law and Ethics and the Business Law Unit 7. Okay, so let's look at the law of agency. Okay, so the law of agency. Now, we are going to look at the definition of agency. We will look at rules of agency. We will also look at creation of agency. We will look at rectification, that is ratification. We will look at agency by estoppel. We will look at agency by operation of law. We will look at duties of an agent and termination of agency. Okay, so the definition from Professor G.H.L. Friedman, Power or Liability Analysis. So the agent is considered in law to represent the other called the principal, in such a way to be able to affect the principal's legal position in respect of strangers to the relationship by the making of contract or disposition of property, right? So here, what are we trying to say? Let's look at it. Yes, the definition is here, the features of definition. So we have what? The agent acts with authority and consent. We have principal legal position is affected. The test of agency is the authority to act, right? So when you check from the definition, you could see that the agent is considered in law to represent the other, according to what Friedman, the principal, right? So in such a way to be able to affect the principal's legal position in respect to strangers to the relationship, right? So if you look at the features, you see that the agent must act on behalf of what? The principal. Whatever the agent legally does affects what the principal what directly. I hope you get that. Yes. Once he signs a contract, it affects the principal. Once the agent sells a property, it is in the name of what? The principal. Now the third party deals with what? The principal through the agent. So if there is anything that the third party, or if there is anything that someone has to do to the principal, yes, the person can do that through the agent. Or I hope you get that. Yes. So you can imagine if, let's say, a car dealer sells a car on behalf of the owner, right? The buyer signs the agreement with the agent, right? So you see that the person is selling on the someone's behalf. So if the buyer signs an agreement with the agent, but the car is legally belongs to, let's say, initially the car was for what? The principal. Now after the signing of the agreement or the contract, you see that the car will be legally belongs to what? The buyer, right? Yes. And so whatever the agent did at that particular signing of the contract, yes, it is in favor of the principal. It is assumed that it was that authority was inferred on him from the principal. I hope that is clear. So let's move on. We have rules, right? Rules of agency. And so for the rules of agency, here we are going to look at some rules of agency, right? So we say whatever a person competent to contract may do himself, he may do through an agent, except for acts which requires personal skill and qualification. That's the first one. Then the second one is the acts of an agent are for all legal purposes. The act of the principal, right? So things regarding or things that requires personal skill, let's say writing an exam, making a will, that one, it cannot be what? Delegated, right? That one, it cannot be given to an agent. I hope that is clear. But let's say something that can be done on behalf of someone, yes, that one is allowed. Okay, yes, so we are saying for the delegation rule, that is the first one. So that one, that agent can do everything with the exception of things that require what? Personal skills or, let's say, qualifications. Okay, yes. And the second part says the acts of an agent are for all legal purposes. The act of the principal. So for the legal effects, here we will say that the act of the agent is the same as the act of the principal. Whatever the agent does is the same as what is in the name of what the principal. So if the agent signs to a particular contract, yes, it is in the name of what that principal. Okay, so that is the rules for rules of agency. Okay, so now let's move on. Creation. So we are going to look at creation of what agency. So agency can be created in so many ways, right? It can be created in so many ways. So we are saying by contract, the agency relationship can be created by contracts, expressed or implied, conduct, relationship, or circumstances. What are we trying to infer here? What are we trying to say? We are saying that it can either be what expressed or implied. I hope that is clear. It can be expressed or implied. Then when we say if the contract is expressed, then what do we mean? Here we are saying that everything about the contract is either orally or written, right? Either orally or written. Everything that you are going to state, it should be orally or in writing. I hope that is clear. Then the implied here that we are talking about, we are saying expressed or implied. So the implied here we are talking about, it means it is created, that particular contract, okay, it's created through conduct of what? Relationship. Okay, it can be long-term business or partners. I hope you get that. Yes. So that second point says there are clear terms of appointment and limits of authority established. Okay. Then we have such contracts may be oral or in what? Writing, as I said. Okay. However, if the agent is to execute a document, the authority must be in writing. This rule is particularly significant when dealing with contracts required by law to be in writing, such as deeds and other formal agreements. So deeds, let's say you are forming a partnership, you are trying to come up with business and you are forming a partnership. So you would need what? A partnership deed. And with this partnership deed, it must be in what? Writing. Okay. Yes, because once there is a contract, even the contract should be in what? Writing. Don't forget under parole evidence rule. Okay. Yes, it should be in form of writing. Other than that, yes, the court can not be what? Enforceable. I hope you get that. Yes. So that is it when we talk about the creation of what? Agency. Okay. Then let's talk about ratification. So when we say the concept of ratification, this is when an agent, let's say, acts without the principal's what? Approval. Okay. The agent acting on his own way without consulting what? The principal. Let's say you have been sent to sign a contract or be on behalf of a particular company. Instead of you going there, maybe if there is any issue rising up before you sign a contract, you let the principal be aware that when you came, there is this and this and that to what was already discussed. So do I need to still go on to sign? So in a situation whereby you do not tell the principal about it and you do it on your own, right? You act without the authority. Yes, the principal can later approve that particular act. So once the principal approve the act of, let's say, you sign that, you sign a particular document or contract, right? Yes, without the principal's consent. Now for the ratification, the principal can later come and approve. That is the ratify we are talking about. He can later come and approve that, oh, even if my agent has signed this, yes, let the deal goes through. Okay. So it makes it legal binding, as if the agent had authority from the principal, right? So we are saying, however, ratification allows the principal to adopt the agent act. Thus, once rectified, the agent act is binding. That is legal binding. So be that as it may, the agent cannot continue to act without authority or exceeds same. Okay. Yes. So that is the ratification we are talking about here. Okay. So the requirement before there can be a valid ratification. Okay, the agent must make a disclosure, right? So the agent must make a disclosure that they were, or he or she is acting on behalf of someone. Okay, so once you come, you just have to declare yourself that, oh yes, I'm working for this, I'm working for that. Okay, or there must be a document from the principal to whoever that you are going to sign an agreement with or a contract with, that yes, you are acting on the person's behalf, right? Then we are saying must be on the frolic of his own, right? So the agent must not be on frolic of his own, right? Here we are talking about acting personally or for personal gain. Acting. So you see that an employee, maybe in the course of them working, the person can just leave the workplace that he is going to visit a friend or someone. So in the course of going, when you come across any accident, yes, the employer is not liable. I hope you get that. Yes. So before there can be a valid ratification, here we are saying the agent must not be on frolic of his own. I hope you get it. You must act according to the orders and authority from the principal. So once the agent make a disclosure and there is the agent is acting under the principal's authority, the agent must have capacity to act. Okay, the agent must have a capacity to act. And we are saying the last one, the principal must also exist at the time of the act. At the time of the act. So an agent acted on, let's say, on behalf of a company that didn't even, let's say, okay, let me put it this way. The principal must also exist at the time of the act. I want to give a certain example so that, let's say the one who sent you, okay, or the one that you are acting on his or her behalf, that person must exist. Okay, so it shouldn't be a situation for this newborn and what's the name, Sensolid and Kellner versus Baxter. Yes, for this particular situation, when you read about it, you see that the agent even acted on behalf of a particular company that is not even in existence, right? Yes, and the court ruled that you can't ratify, right, or you can't act on behalf of something that is not even legally existed. I hope you get that. Yes, and that is the requirements for a valid ratification. Then let's look at the effects of ratification. The effects. So we are saying it has a retroactive effect. Okay, it has a retroactive effect. Then we are saying the principal assumes all rights and liabilities associated with the contract. The agent is to be paid reasonable remuneration. Okay, so once ratified, the act is treated as if the principal had authorized it from the start. I hope you get that. Yes. So what it means is that even though the agent originally had no authority, ratification makes it seem like they had the authority from the what do we call it, the principal, because the agent will sign the contract and then the principal will just ratify it. That is, the principal will just approve it. I hope you get that. Yes, so it is, or it will seem as if, oh yes, whatever the agent did on the part or on behalf of the principal. I hope you get that. Yes. It operates to tell what is unlawful, and so let's move on. Agency by estoppel. Okay. So when we say agency by estoppel, Agency by estoppel is a legal concept that arises when a person or the principal creates the appearance or impression that another person, that is the agent, has the authority to act on their behalf, and a third party reasonably relies on this appearance to their detriment. In essence, agency by estoppel is a form of agency that is implied or created by the actions, representations, or conduct of the principal, right? So estoppel means to allow another to believe in the existence of certain states of affairs, okay? So this happens when a person, yes, that is the principal, makes others believe that someone has the authority to act for them. I hope you get that. Yes, so that is why I'm saying before you even go to a particular event to act on behalf of someone as agent, right? Yes, whilst you are an agent, what you do is you go with an official document from that particular person indicating that yes, truly you have been taken to what represents that person, okay? That is what the agency by estoppel is talking about, okay? So we are saying estoppel means to allow another to believe in the existence of certain states of what affairs, okay? Once the impression is created, the principal cannot say that a different state of affairs exists. Estoppel may come into being by words or conduct, okay? Yes, so that is what we are talking about here, okay? So we are saying if a third party relies on that belief and suffer a loss, the principal cannot deny, okay? Yes, so once you have given the person documents to present to the board that person is acting on behalf of you, once the person sends the document and there is any loss or there is any damage to any party, you, the principal, cannot come to say that you don't know anything about it, or you can't deny the authority you vested in that particular agent. I hope that is clear. Yes, so requirements by estoppel. I think that is where we are now, right? Yes. So requirements by estoppel. 1, a representation by the principal. So the principal does, or you say something to make others believe the agent is what authorized. That is the written document that I initially said. Okay. Yes. Then the second one is the presentation must be relied on, right? So it is talking about reliance. A third party depends on that what belief. It should be a document that someone outside will just believe that, oh, truly, this agent has been vested the authority to act as the principal, right? Then the third one is the third party must not know that the agent lacks what authority. That is, the third party must not know that the agent had no real what authority on grounds. Okay, yes. Then let's look at the effect of estoppel. Principal cannot disclaim liability, right? So once you have given the go ahead, once you have invested the authority in someone to pursue a certain contract for you, yes, you cannot deny any form of liability. I hope that is clear. Yes. And the second one is the liability can be prosecuted against the principal and the agent jointly and severely, right? So the third party can sue, or the one that they are dealing with can sue both the agent and the principal together. And the third one is saying if there is transfer of property, the principal is presumed to have authorized it. So suppose if someone is going to, the agent is going to sell a house, even if it is without the principal's consent, now because he presented a written document and there is a disclosure that yes, I am acting on the part of the principal. If the person even sells a house that is not authorized by the principal, yes, that is how we are going to presume it, because we know the authority has already been vested in him. I hope you get that. Yes. So if property changes hands, it is assumed the principal would agree to it. I hope you get that. Yes, that is why you always need to get a trusted friend, someone that you can rely on to be your agent. Okay. Then agency by operation of law. Agency by operation of law. In this type, no relationship exists. A party just acts because of a looming danger to save the situation, right? So for agency by operation of law, what we are saying is that sometimes someone like the agent will just act in a way to help an emergency, even without any agreement, just to save their principals from harm or danger or any other thing. So the condition here is that an imminent danger which gave the party no other option but to act the way he did. Such an act must be done in good faith, right? So what we are saying is that the condition for the first one, that for an agency by operation of law to rise, one, there must be what? Emergency, something serious about what happened. I hope you get it, or something danger. And secondly, the person must act what? Honestly. The person must act in good faith. Then the third one, we are saying it must be what? Impossible to communicate the principal. So maybe the agency of operation of law comes into context when maybe you are within a particular meeting trying to come up with contract. Then there is a situation whereby you need to call the principal and you are not or you have not been able to reach out to the principal. So here what you do is that you go ahead. That is the agency by operation of law. You go ahead. So that's the third condition. No time to contact the principal. Or maybe you are trying to get him and you are not getting him. So for example, if let's say a ship captain who is an agent, right, sells perishable goods on board to prevent them from routing when the owner, which is the principal, is unreachable, right? So you've given me, let's say, some tomatoes, okay, but then it's rotten. And once the tomatoes are rotten and I'm trying to call you to know what I'm supposed to do, but because I'm not able to reach out to you, yes, I can go ahead to sell those tomatoes. So the agency by operation of law is when an agent is taking care of a certain situation in context just to prevent harm. I hope you get that. So let's move on. Duties of an agent. Duties of an agent. Duty to perform his assigned obligation. Exactly. Do the job assigned, like delivering goods, signing deals, whatever that has been assigned to you, you make sure you do it. Then obedience, that is the hermion, right? So the obedience here, just obey lawful instructions. You must follow the principles, whatever the principal will say. And the third one here, we are saying duty of care and skill. Okay, so duty of care and skill means you need to be very careful and you need to be a skilled person. You must act like someone reasonable in their role. You have to be smart. Okay, yes. And for the fourth one, duty to account. Keep clear records. So if I've given you this, if I've taken something, or if I've given you something to look after, let's say something in a form of sale, right? You are supposed to sell something. You must account for the money and goods handled, the way you handle it. So you need to be able to account for it. Okay. Then non-delegation, confidence and trust. So you don't hand over your duties unless you are told to do so. You have already been taken as an agent, so you don't have any right to, how do we call it? You don't have any right to delegate your duty. Okay, you don't have any right to delegate your duty. So let's move on. The next one is fiduciary duties of an agent. So his duties must not conflict with his own interest. So when we talk about fiduciary duties of an agent, here we are saying that that particular agent must not act in conflict of interest. And that person cannot be of or cannot make a secret what profit, and cannot take what bribes as well. Okay, so let's say you are an agent. I've given you a land to sell. Then you will just try and buy the land yourself, so that you later go and buy that sell that particular land to someone at a higher price. I hope you get that. So you see, you want to make profit, something that has been assigned to you for you to do it on my behalf. Then I'll later pay you. You want to use that particular thing to make what profit. I hope you understand. Yes, and that is what we mean by fiduciary duties of an agent. Okay, yes. Then duties of the principal. Now we are done with the duties of an agent. Now we are going to look at duties of the principal. Yes, and we will finish very soon. The principal is to remunerate the agent in terms of the agreement signed. Okay, indemnify the agent's losses incurred. Okay, so you pay the agent as agreed, and you make sure you cover losses if the agent incurs expense or is sued for doing their job lawfully. So once you take someone as agent or someone as your lawyer, even if the person goes to defend you and the case is not ruled in favor of you, you still have to pay the person. I hope you get that. And if there is anything that the person was sued for, you are the one going to be in charge. So it is part of the duties of the principal. Okay. Then let's look at termination of agency. Termination of agency. So we are going to look at it in some ways. And one is by the act of what? Parties. Okay, by the act of parties. So by the act of parties, that is where we are going to look at mutual agreement, revocation by principal, renunciation by the agent. Sorry, I thought remuneration. Renunciation by what? Agent. So the mutual agreement we are talking about here means that both sides agree to end the relationship. That is mutual agreement. We must all agree to end what? The relationship, that principal-agent relationship. Okay. Then the second one, there must be what? A revocation by what? Principal. And so the principal ends it. The principal can revocate it because I employed you as an agent. So once, if I'm not interested in it, or you've done something that I think is not up to my satisfaction, I can revocate what? The relationship. I hope that is clear. Then renunciation by the agent. So here too, the agent can also quit. In as much as the principal can revocate or quit, the agent can also what? Quit as usual. So a typical example is, let's say a company tells its sales agent to stop working on their behalf. You know, the sales agents, they work on behalf of the company. Do you get it? And so once the company tells the sales agent to stop working on their behalf, that is all. It ends what? The agency. I hope you get that. So let's move on. Termination of agency continued. So the second one is what? By completion. And so by completion here, we means what? When the job is done, the agency ends automatically. Maybe I hired you as what? A lawyer. Once you are done with your job, taking care of a particular situation, that is all. Okay, that is all. We are done. So that is by completion. We can terminate our agency. Okay. Then for the third one, subsequent events. So the subsequent event here, we have death of the principal or agent. So in case death of either the agent or the principal can cause what? The end of the agency. I hope that is clear. Then the destruction of subject matter. So destruction of the subject matter, that is, for example, let's say goods to be sold are what? Destroyed. Okay. Now I appointed you as an agent to make sure you sell a particular land for me, and that land has been what? Seized by what? The court. So it means the subject matter, or the reason why I appointed you as an agent, is no more in contest. So for this matter, you just need to what? We just need to go our separate ways. Okay. Unless maybe I want you to do something else for me before we can continue with the agency. But since I don't want, or I have nothing else to deal with you, yes, we can just go on our separate ways. And the last one is change in law. Change in law makes the agency what? Illegal. right? Yes, you know the laws that governs what agency, and so once you just try to stay, or you just try to find your way out of the law, yes, it makes it what illegal, and with this too, there can be what a termination of the agency. So, for example, let's say if an agent is hired to export goods and later a new law bans export of that product, the agency ends automatically. I appointed you to let's say export some of my goods, okay, and later they have introduced a law that bans what exports. So if I export, let's say, some of the products from the black market, yes, and now because there is ban on the exportation of those products, we can end our agency automatically, and very simple. I hope that is clear. So thank you all for joining me today. Once again, my name is Afari Ernest, and this brings us to the end of the agency theory, or the law of agency. Okay, yes. So we will meet again to discuss about other subtopics. Okay, all right. So thank you very much and have a wonderful day. Please subscribe, share, and like. Bye.